Good morning, everyone. This meeting is called to order. Mr. Trobman, has anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
How are we today?
Very well, thank you.
Well, good. Let's dig right in. No cases to reconsider under agenda item 3.
Correct, no case.
Thank you.
No tax cases on docket 26 for agenda item 4.
Correct, no case.
No fair housing cases, no wage claim cases pulled for additional discussion.
Yes, sir, that is correct. None pulled for additional discussion, but you should have received the wage claim short form dissent list for docket 26.
I move we accept staff recommendations on the remaining wage claim cases on docket 26.
I second the motion, except for those cases of which I'm dissenting as reflected on the wage claim short form dissent list for docket 26.
I concur with the chairman's motion, except for cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 26.
Motion passes with the exceptions noted.
Thank you.
Thank you. Let's move to agenda item 7, consideration of unemployment insurance cases, docket 26. Please proceed when you're ready.
Case number 2863268, Commissioner Alvarez.
The AT should be reversed. The evidence in the record established that the agency received written communications from the claimant within the appeal deadline. The AT held that the claimant's appeal was not timely because it was not sent in to the correct department. Such a narrow and constraining ruling is inconsistent with the statutory intent of the Texas Unemployment and Compensation Act to protect parties' appeal rights, and it is contrary to the agency's standard practice in establishing a claimant's date of appeal. The claimant's written correspondence, which was received within the appeal deadline, should be considered a timely appeal to the determinations at issue, and the case should be resubmitted on the merits. Reverse the AT, timely appeal, and resubmit.
With the exception of the chargeback ruling, I agree that the totality of the evidence in this case supports the appeal tribunal's decision. However, some of the appeal tribunal's findings were based on evidence that was not entered into the record. As such, we should conduct a limited remand for the purposes of authenticating the claimant's non-entered documentary evidence and properly entering that evidence into the record.
I concur with Commissioner Demerson.
Thank you. We will remand the case. And
Case-
I'm sorry, since this will result in a written decision, did you wish to dissent, Commissioner Alvarez?
Yes, short form.
Yes, sir.
Case number 2904607, Commissioner Dimerson.
We should reverse the appeal tribunal decision regarding good cause. The owner was out of state on vacation during the date of the hearing. Because the employer had not received the hearing notice prior to leaving, he had not been able to make other arrangements for the hearing. Thus, because the employer was on a previously planned vacation, the employer has established good cause for its non-appearance. We should reverse the AT decision, good cause for the employer's non-appearance, resubmit for merits testimony. However, even if the employer did not have good cause, the available evidence supports reversing on the timeliness and chargeback issues. Regarding the employer's response to the notice of maximum potential chargeback, the employer stated in its appeal that it responded immediately to the inquiry. Because the employer's response bears no agency receipt stamp or fax date, and no copy of an envelope is contained in TWC records, the response should be deemed timely based on the employer's assertion. As to the underlying chargeback issue, both the employer's response and appeal indicate that the job separation occurred when the claimant quit for personal reasons. As such, the employer should not be charged. We should modify the AT, no good cause for the employer's non-appearance, timely employer response to the notice of maximum potential chargeback, no chargeback.
The AT decision should be affirmed. The employer failed to attend the AT1 hearing because he did not open the notice of telephone hearing packet after receiving it in the mail and was therefore unaware of the hearing time and date. This is certainly a factor well within the employer's control. On the underlying timeliness issue, the employer claims to have submitted a timely protest to the notice of maximum potential chargeback, but he has provided no evidence to support that claim. The evidence on the record supports the determination ruling that protest was untimely. Affirm the AT, no employer good cause for the non-appearance at AT1, no timely protest to the notice of maximum potential chargeback.
Reverse the AT, employer established good cause for AT1, resubmit.
We'll resubmit the case.
Case number 30108 5-2, Commissioner Alvarez.
The AT decision should be reversed. The claimant quit because the employer was going to implement a mandatory COVID-19 vaccine policy. The claimant objected to the vaccine on religious grounds. On October 11, 2021, Governor Abbott issued Executive Order GA 40 that prohibited any employer in Texas from compelling the receipt of a COVID-19 vaccine by any employee who objects to such vaccination for any reason of personal conscience based on a religious belief or for medical reasons. Moreover, on December 8th of 2021, all three commissioners here today signed a letter to Texas employers reinforcing Governor Abbott's order. We wrote that it is unlikely that a claimant will be disqualified from receiving UI benefits if the separation was caused by the employee's failure to receive the COVID-19 vaccine. We also advised employers not to mandate a vaccine without notifying employees of the necessary exemptions and processing those exemptions in good faith. There is no indication that such action was taken by the employer in this case. Since the employer acted contrary to the governor's order and the commissioner's statement, the claimant was separated for non-disqualifying reasons. Reverse AT, no voluntary leaving, no chargeback due to disaster.
The appeal tribunal decision should be affirmed. Prior to October 11th, the claimant resigned after a tense day of work between himself, his supervisor, and a new coworker. However, there is no indication that the claimant ever provided the employer an opportunity to remedy any concerns he might have had with the supervisor or the new coworker. Since the claimant failed to provide the employer an adequate opportunity to remedy his concerns, he quit without work-connected good cause, and we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 302-6379, Commissioner Alvarez.
The AT decision should be reversed. Due to an injury, the claimant was restricted by her doctor to light duty work. The claimant was sent home without pay indefinitely by the employer because the employer could not accommodate her work restrictions. The claimant was separated when she was sent home without pay for at least 2 weeks due to her injury. She was involuntarily separated due to her medical condition and not for misconduct connected with the work. Reverse AT, no misconduct, bill reimbursing employer.
The appeal tribunal decision should be modified. The claimant quit due to a medical reason, which was a personal reason, and there's no indication that such reason was connected with work. As such, the claimant quit without good cause connected with the work, and we should modify the AT decision. Voluntary leaving, reimbursing employer not billed, sever adequate response.
Reverse the AT, no misconduct, bill reimbursing employer, void adequate response, memo to investigate claimant's ability.
Commissioner Alvarez, I didn't catch your vote on the adequate response issue.
Void adequate response.
Thank you.
Short form dissent.
Yes, sir, Commissioner Henderson. And we will send the memo, sir.
Case number 302-6700, Commissioner Alvarez.
The decision is not supportable. The claimant initially put in her notice to quit because despite the employer delaying her vacation policy, her vaccination policy, the claimant believed her supervisor would continue to harass her. The claimant's concerns were correct. Her supervisor spat in her face and made demeaning and racist comments toward her and demanded she leave the property. The employer was present at the hearing, but did not dispute the claimant's testimony regarding her treatment. The claimant could not go to anyone as her supervisor was the brother of the company's president. The claimant had good cause to leave. Reverse AT, no voluntary leaving, chargeback. Although I believe there is enough evidence to find that the claimant had good cause to quit, I would also agree to rehear the case to enter into the record evidence and to clarify the claimant's supervisor's position with the employer.
The appeal tribunal decision should be affirmed. While I do not condone the alleged behavior of the employer's owner, the claimant stated that she did not bring her concerns to the attention of the employer's HR manager. As such, the employer was not afforded an adequate opportunity to remedy the claimant's concerns. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 304-3608, Commissioner Alvarez.
The AT decision is not supportable. The claimant had a personal health emergency that required her to urgently leave the employer's premises for hygiene products. She was only gone for 26 minutes and notified her supervisor when she returned. She was nevertheless discharged. The claimant had a compelling reason to briefly leave the employer's premises, and her actions did not constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void, adequate response.
The appeal tribunal decision should be modified. Per the employer, the claimant was separated from employment due to leaving the premises without clocking out and without notification to her supervisor. The employer stated that both actions were policy violations and subjected the claimant to termination. While the claimant may have had a pressing personal matter to attend to, she was still responsible for following the employer's rules. We should therefore modify the AT decision, misconduct, no chargeback, sever, adequate response.
Modify the AT, misconduct, no chargeback, sever, adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3050496, Commissioner Dimerson.
We should modify the appeal tribunal decision because the facts of this case support the conclusion that the job separation resulted from the COVID-19 disaster. The claimant should be qualified for benefits and the employer's account should be protected from charge. We should modify the AT decision, no misconduct, no chargeback, disaster.
I would agree with Commissioner Demerson.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response.
The majority vote is a pay.
Short form dissent.
Yes, sir, thank you.
Case number 3056332, Commissioner Dimerson.
The appeal tribunal decision should be modified. The majority of the events that led to the job separation in this case were the result of COVID-19 related circumstances. As such, the claimant should be qualified for benefits and the employer's account should be protected from charge due to disaster. We should therefore modify the AT decision, no misconduct, no chargeback, disaster, void adequate response ruling.
I would agree with Commissioner Demerson.
Reverse the AT, no misconduct, chargeback, void adequate response. Short form dissent.
Thank you, sir.
Case number 3056512, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The employer in this case is a home health agency. Per commission president in the home health referral industry, the working relationship continues until one side notifies the other that the working relationship is ended. In this case, the employer had a policy that required temporary workers like the claimant to request a new assignment or the company will assume the worker no longer desires work. There's no indication that the claimant requested a new assignment per policy. As such, the claimant ended the working relationship and did so without work-connected good cause. Accordingly, the employer's account should not be charged. We should therefore reverse the AT decision, no chargeback.
The claimant was on an on-call as-needed employee who usually performed services for a single client over many years. The employer testified the claimant did not need to be asked if she wanted another assignment because she only worked for one client. In accordance with commission precedent, since the claimant was an on-call as-needed employee who did not know whether further work would be available at the end of her assignment, she was effectively laid off. Affirm the AT, chargeback.
Reverse the AT, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3056630, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I agree that the claimant filed a valid claim. As to the job separation, the employer, a healthcare provider, implemented a vaccine requirement which allowed employees to file an exemption. Although the claimant initially submitted a religious exemption, he voluntarily rescinded it a few days later. Furthermore, the claimant had previously complied with the employer's longstanding vaccination policy that made some vaccines a condition of employment. Thus, because the claimant did not avail himself of the employer's exemption procedure and had complied with the vaccine requirements in the past, he was discharged under disqualifying circumstances. We should modify the AT decision, valid claim, misconduct, reimburse an employer not billed, sever the adequate response issue.
The AT decision should be modified. I agree that the claim is valid. Regarding the separation, the claimant separated because the employer implemented a COVID vaccine requirement. On October 11, 2021, Governor Abbott issued an executive order prohibiting entities from compelling the receipt of the COVID-19 vaccine to any individual who objects for any reason of personal conscience. Moreover, on December 8, 2021, all three commissioners here today signed a letter to Texas employers reinforcing Governor Abbott's order. We wrote that it is unlikely that a claimant will be disqualified from receiving UI benefits if the separation was caused by the employee's failure to receive the COVID-19 vaccine. We also advised employers not to mandate a vaccine without notifying employees of the necessary exemptions and processing those exemptions in good faith. The employer's exemptions did not include an exemption for personal conscience, and their mandate was contrary to the governor's order. Modify the AT, valid claim, no misconduct, bill reimburse an employer, void adequate response.
Modify the AT, valid claim, misconduct, reimbursing employer not billed, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3082826, Commissioner Dimerson.
We should modify the appeal tribunal decision because the facts of this case support the conclusion that the job separation resulted from the COVID-19 disaster. The claimant should be qualified for benefits and the employer's account should be protected from charge. We should modify the AT decision, no voluntary leaving, no chargeback, disaster.
I would agree with Commissioner Dimerson.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response. Short form dissent.
Thank you, sir.
Case number 3083980, Commissioner Dimerson.
The appeal tribunal decision should be modified. The following documents for this case contain the employer's appeal. The employer's appeal stated that the claimant was hired in a patient access representative position that required vaccination. In addition, the evidence in this case establishes that the claimant stopped performing services for pay prior to October 11, 2021. As such, the employer, a public health system, was reasonable in its actions and the claimant was separated from the job under disqualifying circumstances. We should therefore modify the AT decision, misconduct, reimburse an employer not billed, sever adequate response.
The AT decision should be reversed. The claimant quit because the employer was going to implement a mandatory 19 vaccine policy. The claimant objected to the vaccine on religious grounds. On October 11, 2021, Governor Abbott issued Executive Order GA40 that prohibited any employer in Texas from compelling the receipt of any COVID-19 vaccine by an employee who objects to such vaccination for any reason of personal conscience based on religious belief or for medical reasons. Moreover, on December 8, 2021, all three commissioners here today signed a letter to Texas employers reinforcing Governor Abbott's order. We wrote that it is unlikely that a claimant will be disqualified from receiving UI benefits if the separation was caused by the employee's failure to receive the COVID-19 vaccine. We also advised employers not to mandate a vaccine without notifying employees of unnecessary exemptions and processing those exemptions in good faith. The claimant applied for a religious exemption. The employer denied her exemption despite having previously granted her exemption request for an annual flu vaccination. Since the employer acted contrary to the governor's order and the commissioner's statement, the claimant was separated for non-disqualifying reasons. Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3084556, Commissioner Dimerson.
We should modify the appeal tribunal decision. The employer, a healthcare provider, implemented the vaccine requirement. Although the employer allowed employees to file an exemption, the claimant chose not to submit one. Furthermore, the claimant had previously complied with the employer's longstanding vaccination policy that required the flu vaccine as a condition of employment. Thus, because the claimant did not avail herself of the employer's exemption procedure and had complied with the vaccine requirement in the past, she was discharged under disqualifying circumstances. We should modify the AT decision, misconduct, reimbursing employer not billed, sever the adequate response issue.
The AT decision should be reversed. The claimant quit because the employer was going to implement a mandatory COVID-19 vaccine policy. The claimant objected to the vaccine for reasons of personal conscience. On October 11, 2021, Governor Abbott issued Executive Order GA 40 that prohibited any employer in Texas from compelling the receipt of a COVID-19 vaccine by any employee who objects to such vaccination for any reason of personal conscience based on the religious belief or medical reasons. Moreover, on December 8, 2021, all three commissioners here today signed a letter to Texas employer reinforcing Governor Abbott's order. We wrote that it is unlikely that the claimant will be disqualified from receiving UI benefits if the separation was caused by the employee's failure to receive the COVID-19 vaccine. We also advised employers not to mandate a vaccine without notifying employees of the necessary exemptions and processing those exemptions in good faith. The employer's exemptions did not include an exemption for personal conscience, and their mandate was contrary to the governor's order. Since the employer acted contrary to the governor's order and the commissioner's statement, the claimant was separated for non-disqualifying reasons. Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
Modify the AT, misconduct, reimbursing employer not billed, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3084569, Commissioner Dimerson.
The appeal tribunal decision should be modified. The claimant's job separation was the result of not complying with an employer policy. The evidence in this case establishes that the claimant stopped performing services for pay prior to October 11, 2021. As such, the employer, a hospital, was reasonable in its actions, and the claimant was separated from the job under disqualifying circumstances. We should therefore modify the AT decision, misconduct, reimbursing employer not bill, sever adequate response.
The AT decision should be reversed. The claimant quit because the employer was going to implement a mandatory COVID-19 vaccine policy. The claimant objected to the vaccine for medical reasons. On October 11, 2021, Governor Abbott issued Executive Order GA 40 that prohibited any employer in Texas from compelling the receipt of any COVID-19 vaccine by any employee who objects to such vaccination for any reasons of personal conscience, based on a religious belief or for medical reasons. Moreover, on December 8, 2021, all three commissioners here today signed a letter to Texas employers reinforcing Governor Abbott's order. We wrote that it is unlikely that the claimant will be disqualified from receiving UI benefits in the separation if the separation was caused by the employee's failure to receive the COVID-19 vaccine. We also advise employers not to mandate a vaccine without notifying employees of necessary exemptions and processing those exemptions in good faith. The claimant applied for medical exemption based on her autoimmune disorder. The employer denied her exemptions without giving a reason for the denial or giving her the opportunity to appeal. Since the employer acted contrary to the governor's order and the commissioner's statement, the claimant was separated for non-disqualifying reasons. Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3101440, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, the claimant initiated the job separation when he entered a 30-day rehabilitation program while work was still available. However, because the job separation resulted from the claimant's medical condition, he should continue to be qualified for benefits, and the employer's account should be protected from charge under medical separation analysis. We should modify the AT decision, no voluntary leaving, no chargeback, MVI.
I would agree with Commissioner Dimerson.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response. Short form dissent.
Thank you, sir.
Case number 3102170, Commissioner Alvarez.
The decision is not supportable. The claimant quit because there were 4 to 5 instances in which his pay was delayed and because his hours were reduced. The record was not fully developed regarding the pay delays, and the claimant's hours in the weeks leading to his separation were not clarified. This case should be reheard to properly develop on the record regarding the pay delays and the claimant's weekly hours. Rehear.
We should affirm the appeal tribunal decision. Fluctuations in the claimant's pay were seasonal. A review of the claimant's wage records indicates that when comparing by quarters, the claimant's pay did not decrease by 20% or more. As such, the claimant did not establish good cause to quit. We should affirm the AT decision, voluntary leaving, no chargeback.
Rehear.
We will rehear the case.
Case number 3102892, Commissioner Alvarez.
The AT decision should be modified. I do not contest that the claimant filed a late appeal regarding the issue of ability. The claimant was found to be unable to work since the start of her UI claim on April 4th of 2021 due to having contracted COVID. She subsequently informed the agency that she was able to work and the ineligibility was closed as of April 17, 2021 by a determination dated June 15, 2021. The AT voided that determination in error by using an inappropriate standard of evidence. A party statement to the agency that they have recovered from COVID and are able to work is sufficient to close the ineligibility. Modify the AT late appeal, reinstate June 15, 2021 determination, claimant ineligible due to ability from April 4, 2021 through April 17, 2021, and memo to UIAOS to contact and assist the claimant in filing a backdated PUA claim.
We should affirm the appeal tribunal decision. Regarding timeliness, TWC records established that the claimant received the determination at issue electronically, and as she had elected, and opened it after the appeal deadline. As such, the claimant's appeal is not timely. However, the commission may assume continuing jurisdiction of the open ability issue 14 days prior to the date of the late appeal if the facts so warrant. Here, the claimant repeatedly testified that per her doctor's advice, she could no longer work hands-on with students or around others. The claimant had worked as a teacher's aide continuously for the previous 6 years and was looking for substitute positions at a different school. This type of work does not regularly offer fully remote positions. Thus, because the claimant was not shown she was medically able to work, assuming continuing jurisdiction is not warranted. We should affirm the AT decision. The claimant filed a late appeal ability not eligible beginning April 4th, 2021.
Modify the AT, untimely claimant appeal, claimant not able to work from April 4th, 2021 through May 15, 2021. Memo in accordance with staff recommendation.
Was your closure date May 15th, 2021? And you had voted also the appeal was late.
That's correct.
Okay. We don't have a majority vote on the closure date. So Commissioner Alvarez, your closure date was April 17th,
That's correct.
and the chairman's closure date is May 15th.
I will agree with with Chairman Daniel. Did I get that right, guys? Okay. I'll agree with with Chairman Daniel.
Okay, there's also a conflict between the two memos that have been requested. The memo that you requested, Mr. Chairman, requested that the claim be converted to PUA claim. And your memo only requested, Commissioner Alvarez, that the claimant be contacted about filing a backdated PUA claim without any mention of what should happen to the current initial claim.
I'll agree to Commissioner Alvarez's request for a memo.
Thank you very much, sir.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3126745, Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant was discharged after he failed to torque the lug nuts on a vehicle during a pre-delivery inspection. During his testimony, the claimant admitted that he probably forgot to tighten the lug nuts. Fortunately, the customer who purchased the vehicle was not hurt. However, failing to torque the lug nuts could have resulted in disastrous or deadly consequences for the driver. Because the claimant's neglect jeopardized the life or property of another, the claimant was discharged for misconduct connected with the work. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
we should accept staff's recommendation to affirm the appeal tribunal decision. The claimant was discharged after a customer returned a car that had loose lug nuts. The claimant had performed a pre-delivery inspection on the car three days before the customer returned the car, but he could not remember if he failed to tighten the lug nuts on the car. As there is no direct evidence that the claimant failed to tighten the lug nuts, and it is possible that there was another person for the loose lug nuts, another reason for the loose lug nuts in between the time the claimant inspected the car and the customer returned the car, the employer has failed to present sufficient proof that the claimant's actions violated the employer's procedures by failing to tighten the lug nuts. Thus, there is insufficient evidence to prove that the claimant committed misconduct connected with the work. We should affirm the appeal tribunal decision, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 3130769, Commissioner Alvarez.
The AT decision should be modified. The claimant testified that he stopped working for the employer due to hospitalization for a surgery, and he had notified the employer of the procedure. When the claimant returned to work after his recovery from multiple surgeries, he learned that he had been discharged. The employer's response to the notice of the application did not provide any detail on the separation, and the employer failed to appear at the hearing. Commission precedents holds that the separation occurred when the claimant stopped working for the employer, and the record shows that he provided proper notice to the employer. Therefore, the record shows that the claimant was involuntarily separated due to a medically verified illness. So the employer's account should be protected from charge. Modify the AT, no misconduct, no chargeback due to MBI.
We should affirm the appeal tribunal decision by failing to keep the employer informed of his status and his need for additional leave based on another medical condition. The claimant failed to protect his job and voluntarily left his last work without good cause connected with the work. Should therefore affirm the AT decision, voluntary leaving, no chargeback. However, my fellow commissioners believe that the claimant should be qualified for benefits because the job separation resulted from the claimant's medically verified illness. The employer's account should remain protected from charge under medical separation analysis. Modify the AT decision, no voluntary leaving, no chargeback, MBI.
Affirm the AT, voluntary leaving, no chargeback.
Chair, I would agree with the chairman.
Majority vote is voluntary leaving, no chargeback.
Short form dissent.
Thank you, Commissioner Alvarez.
Case number 3151834, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant was tasked with completing a backlog of assignments. The claimant failed to complete this task. While the claimant stated that she was trying her best to catch up, two employer witnesses stated that the claimant never asked for help, and as such, no one was assigned to help the claimant. Since the claimant failed to ask for assistance in clearing the backlog, she did not explore a reasonable option to get the backlog cleared up on time. As such, misconduct was established. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, since the AT decision stated that the claimant missed many days due to being sick, which contributed to the backlog, I could also support a vote to qualify the claimant for benefits and to protect the employer's account from charge under medical separation analysis. Accordingly, we should modify the AT decision, no misconduct, no chargeback, MBI.
Ms. Miller, I would agree to no misconduct, no chargeback, MBI.
Affirm the AT, no misconduct, chargeback.
Majority vote is pay and protect MBI.
Short form dissent.
Yes, sir. That was the last case pulled for individual discussion under this agenda item on docket 26. You should have received the UI short form dissent list for docket 26.
I move we accept staff recommendations on the remaining UI cases on docket 26.
I second the motion except for those cases on which I'm dissenting as reflected on UI short form dissent list for docket 26.
Concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 26.
Motion passes with the exceptions noted.
Thank you, sir.
Thank you very much. We'll take a short break.
Yes, sir.
This is agenda item 8, chapter 808, Youth Driver Education Funding Program.
In an open meeting on February 8th, 2022, the commission approved the proposed rule to add chapter 808 regarding funding youth driver education and testing for eligible populations. The proposed rule amendments were published on February 25th, 2022 issue of the Texas Register for a 30-day public comment period. Public comments were received. Staff reviewed and responded to those comments, and as a result of those comments, modified the proposed rules. Changes were made to clarify that applications will be accepted in more than one way, that staff will contact applicants whose eligibility cannot be determined based on provided documents, that if a driver's education provider requires payment prior to registration, applicants should not register prior to applying for the program, and removed language to clarify what would trigger the 3-month waiting period. Staff recommends adopting the final rule for chapter 808. Should the commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements for the Texas Register and the Office of the Secretary of State. This concludes my presentation. I'm happy to answer any questions.
Comments or questions?
I have one comment. Well, I have one question. Can you ask me how we're going to market this?
We are going to be making a push later this summer, August or September, to publicize this through various media outlets. There will also be a press release. We are also reaching out to our partner organizations and our transition centers and workforce solutions offices. We are developing a one-pager desk aid for staff that may encounter youth that are eligible for this program to guide them through quickly how to apply for this program.
So you're working closely with Angela, our communications team and all them? You're going to work with them? Great. No other questions, Chairman?
Man, I was going to add, guys may want to add the Trucking Association, John Esparza's team over there. They had some interest in these efforts. And so quite often, if a student obtains a driver's license, then they may look at the opportunities that are out there in the CDL world as well. So, but the driver's license is the beginning, the start.
Yeah, we could definitely work with them.
Is there a motion?
Chairman, I move that we adopt the new chapter 808 regarding the Youth Driver Education Funding Program with the changes recommended by staff.
Second.
It's been moved and seconded. We're unanimous. Thank you.
Thank
It's agenda item 9, chapter 840, WIOA eligible training providers.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Cerna. For the record, I'm Joel Mullins with Workforce Development. This morning for your consideration are the final rules for Chapter 840, which will clarify requirements for participants, local workforce development boards, and eligible training providers. The proposed rules were published in the March 25th, 2022 issue of the Texas Register for a 30-day public comment period. One comment was received, although staff did not make any changes to the rule based on this comment. This morning, staff seeks direction on the adoption of the Chapter 840 final rules as provided in your meeting materials, and I'm happy to answer any questions.
Comments or questions?
None here, Chairman.
None.
Is there a motion?
Chairman, I move that we adopt the amendments to 40 Texas Administrative Code, Chapter 840, WIOA eligible training providers as recommended by staff.
A second.
Been moved and seconded. We're unanimous. Thank you. This is agenda item 10, chapter 849, employment training services for dislocated workers.
Once again, for the record, I'm Joel Mullins with Workforce Development. Today, for your consideration are the final rules for Chapter 849, which will align the rules with the DOL's TAA final rule and will serve as the 4-year rule review as required by the Texas Government Code. The proposed rules were published in the May 6th, 2022 issue of the Texas Register for a 30-day public comment period. No comments were received. This morning, staff seeks direction on the adoption of the Chapter 849 final rules as provided in your meeting materials, and I'm happy to answer any questions.
Comments or questions?
None here, Chairman.
None.
Is there a motion?
I move that we adopt the amendments to 40 Texas Administrative Code, Chapter 849 as recommended by staff.
A second.
It's been moved and seconded. We're unanimous.
Thank you.
So agenda item 11, approval of the 2022 non-discrimination plan.
Good morning. For the record, I am John Graytock, the statewide Equal Opportunity Officer. This plan is to provide equal access to participants and to protect the civil rights of those who are involved in the workforce system throughout the state. I want to recognize the work of Ms. Connie Zubaldia. She's our statewide EO coordinator and spent quite a bit of time on this plan. The plan has been reviewed by the governor. The next step is for the commission to consider it, and then it will be sent to the Department of Labor. Therefore, the staff asks that the commission adopt the 2022 non-discrimination plan subject to minor non-substantive edits. That concludes the presentation. I'm available for any questions.
Comments or questions?
Only comment I have to say is it's nice to see you again, John.
Same here, Commissioner.
No, here.
No,
No.
I thought you were going to ask me.
I think John's
He was
been,
using my barber.
John's been here before. So.
I didn't see him in a long time.
We're trying to set a trend here. You know.
Is there a motion?
Chairman, I move that we adopt the 2022 non-discrimination plan for submission to the Civil Rights Center of the United States Department of Labor as recommended by staff.
A second.
It's been moved and seconded. We're unanimous.
Thank you.
Thank you. So agenda item 12, board nominations.
Good morning, Chairman, Commissioners, and Mr. Cerna. For the record, Cherie Dudley with the Workforce Development Division. This morning for your consideration, we have Workforce Board nominations for Capital Area, Golden Crescent, and Gulf Coast. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Comments or questions?
None here, Chairman.
Is there a motion?
Chairman, I move that we approve the board nominees for Capital Area, Golden Crescent, and Gulf Coast.
Second.
So moved and seconded. We're unanimous.
Thank you.
Thank you. Showing nothing on the agenda for agenda items 13, 14, 15, 16. Is there a legislative report? How about an executive director's report? Not today. Is there any other order of business come before the commission?
Yes, Chairman, I'd like to ask Ed for something. In February 2020, Governor Abbott provided revised charges to the tri-agency members. Readiness, completion, transition, upskilling, educator pipeline, partnerships, infrastructure. Ed, I would like staff to host a work session to facilitate discussions between the commissioners, TWC program staff, and representation from the boards to do the following. Provide an update on TWC and board progress on tri-agency charges. Discuss priorities of the commissioners and TWC on how they connect to those tri-agency charges. Discuss the implementation of commission and TWC priorities at the board level, facilitating communications, feedback, and best practices sharing between the agency and the boards, as well as members of the boards. Create a plan to improve communication and interaction between the tri-agency and the commissioners so our agency can effectively contribute to the meeting of the governor's charges. 5, develop innovative strategies to proactively address the needs of employers and employees in Texas and strengthen the agency's relevance in workforce development and encourage workforce development boards to work across areas to support a stronger Texas economy.
Yes, sir. We'll put a plan together and present it to the each office so we can get it on the scheduled agenda. Or
Thank
not
you.
agenda, but a scheduled one.
So Commissioner Alvarez, you're asking for a work session?
I am.
Session, okay.
Anything else?
I wanted to basically thank the Workforce Solution Offices, the CEOs and EDs for attending the Texas Economic Development Council's mid-year conference, and then to congratulate those Workforce Solution Offices that won awards. There was Workforce Excellence Awards presented. I think Workforce Solutions Borderplex actually, team out of El Paso actually won an award. And Ed, thank you for attending. Ed was actually out on vacation, but came over to attend that conference, and staff did a phenomenal job. Courtney, I see her in the audience. You moderated a panel. I called her Courageous Courtney, and took care of business. But I really appreciate the work, the staff being there. This was the first. Well, they normally have workforce efforts with TEDC, and we really had a tremendous turnout of workforce the workforce team there at the conference. And so Commissioner Alvarez, thanks for joining us here. at that conference as well. I saw Tamara, Adrian Lopez, Laurie was signed up, Marion, Martin Aguirre, and then Ken Trevino and Doug were all there representing the world of workforce. So thank you for your participation.
Anything else? Is there a motion to adjourn?
Chairman, I move that we adjourn.
I second that motion.
Been moved and seconded that we adjourn, and we're adjourned.